Welcome, everyone. Give us a few more minutes to let the group come in. I've got about 11:58 Eastern Time.
Huh.
Yeah. Welcome, welcome. Very, very large group today to hear Russ opine on the charitable cases and legislative updates. So, more tax geeks in this world than I had originally estimated. Said with love, Russ. Said with love.
Well, I'm going to try to be factual. We won't do much opining here, I hope.
Do some opining around the edges.
Yeah.
Got right at noon Eastern, so I'll wait another minute or so, and we will get started. Always important. I want to make sure you can see me and hear the screen. Probably more important that you'll see Russ here in a moment. But if those of you who have been on prior webinars, you know sort of the drill. If you could raise your hands, if you can see me and hear. Okay, very good. Thank you, thank you, thank you. God, you guys are experts. Like 50 people raised their hands, and now everybody's lowered their hands. But very good. I think I can go in and do that too. So good job. Perfect. Well, we're going to go ahead and get started. So I am Brian Klontz, President of Charitable Solutions, and have my partner Russ Willis as part of Charitable Solutions that helps with non-cash research and a lot of due diligence and more complex planning with illiquid gifts. Will be leading us today through, you see there, the top 5 charitable cases and legislative updates impacting 2022. So I'm very excited to hear this and enjoyed putting this presentation together with Russ. And so again, he'll be really leading us through. Similar to past webinars, we do not send out the slides directly, but do so indirectly, in that after our second run at this next Tuesday, we will save the best recorded one and then send that out via link with Q&A with any responses from the chat as well as a combination of both of the webinars. So that will come out, so you'll be able to watch this over and over again and share it with friends and neighbors and all that good stuff, but you'll be able to have all the slides sort of in that way. So that little bit of housekeeping right out of the gate. So those of you who have also done this in the past, I hate doing this every time, but very quickly, sort of the random things that we do. As a firm, our mission is to help make charitable gifts happen that otherwise wouldn't. So we've got a team now of 22, continues to grow in that space. We do emergency assistance fund administration. You can sort of read through that. I won't go through it too much. Doing a lot of that in the COVID space, unfortunately, as a third-party administrator. Doing professional advisor CE, things like this. I've got, I think, 3 or 4 scheduled for the rest of this week. Doing CE training, so we did about 75 of those was the number for last year that either myself or the firm had completed. Still do a number of those, obviously more virtual than not these days. I'll jump over here to charitable appraisal. So we're spending a lot of time in this space. So my little pitch or tagline is, if it can be donated to charity, we can appraise it. So we now have a team of 6 appraisers across various specialty disciplines. We just had an internal firm meeting this morning, and I mentioned we did a project where one of our appraisers appraised a very large collection, I guess it would be called, of bourbon. And so, yes, everybody said they wanted to be a taste tester and all that good stuff. So the point was that this was a donor, wanted to give a large, I think it was $150,000 to $200,000 of bourbon to a charity and needed a qualified appraiser. So you can see here our primary activities around business interests, cryptocurrency, restricted stock, and life insurance. That'd be the bulk. but also doing fractional real estate interests. You can see their precious metal, oil and gas, art, and collectibles. So again, if it can be donated, we can appraise it. We only do charitable appraisals, so it's only in that particular space. So clearly know all of the rules there. Charitable gift annuity risk management. So we did a fair number of these pools last year. We have a couple actuaries on staff where we do actuarial stress testing, full analysis of any gift annuity pools, primarily those that are 10 million or more, and you can sort of see the rest of that. Our particular expertise is around very large or concentrated risks and when those thresholds are crossed. And then to the extent that is the case, then we do also reinsurance design, sort of when that makes sense, when it doesn't make sense, at what amount, and so forth. By far had the largest year ever in that space, and we've been doing that since 1998. And then again, can do the design and brokerage for that, again, as appropriate. Then we have sort of the two primary activities, again, getting back to the helping charitable gifts happen that otherwise wouldn't. One is in the National Gift Annuity Foundation, where we are able to take on gift annuities now in all 50 states. We are now at over 650, I think 650 contracts, so growing very quickly. We're almost 60 million in assets now, so that's since the last quarter when we did this. And the key point is all 50 states were able to issue the gift annuity directly. We take all the risk, all the administration, handle the investment, and then 100% of the residuum is then passed back to the charity by grant, the charity or charities that the donor was trying to give it to in the first place. So a lot of activity in this space. We can do illiquid gifts into that as well. Real estate, we've done a couple retained life estates for gift annuities, S-Corp stock, and so forth. So a lot of activity in this space. And then finally, the non-cash asset risk management. It's about half of our activity. We do this through the Decami Foundation and the Decami Asset Trust, where, again, if a charity is offered any, and I mean any kind of illiquid or complex gift, and they are unable, unwilling, or don't have the time or other capacity to be able to take in that gift, rather than saying no, they can refer that over to us. We do all due diligence, all compliance, receipt, management, sale, and then when sold, we then do a grant of the net proceeds, less our fee. This was $1.6 billion completed since inception. Last year alone, which is on my next slide, which I think hopefully will be informative to the group, we did $1.13 billion just last year, so that'd be added, so we're over $3 billion now in total donations. So important. 100% of those were declined. Business interests in every form, real estate, every form, including international for both of those, cryptocurrency, number of other types of gifts. So this is our primary activity with our team. There are 6 attorneys in addition to myself. Russ obviously is one of our lead business attorneys in particular. And so in that way, again, we're able to help capture these gifts. So the next slide, do this very quickly, I want to get to the meat of this, is our sort of closed out numbers for last year. And so this is just in non-cash gifts, 100% decline. So I've said that 3 times now. Got to keep reinforcing that point. So we did $1.1 billion in donations, 260 transactions. It took about, we think, 1,700 to 1,900 referrals from charities. So we only get the referrals from charities that have a great donor. We always say a great donor with a good asset wanting to do good things. That charity was unable to accept it, again, for whatever reason. And then because of that, out of that 1,700 to 1,900, we were able to complete 260. Quick average there, you figured out, it is eerily consistent in the last 3 years, was about $4.3 million per donation. So ton of activity. And this, as sort of a context, our most recent record year was exactly 100 donations for $406 million. So we nearly tripled both the number and the value off of our record. So this is a massive megatrend of these types of assets that are being donated to charities through us and through others as well. So the non-cash, in particular, higher end non-cash transactions prior to merger acquisition, other types of exits. You can see here, again, I'm not going to spend a lot of time. We did 61 real estate in every form, again, you can imagine, including international for $42 million, 151 business interests, so over the billion were in the business interest, and we broke that down, which we thought would be helpful for C Corp, S Corp, and LLCs. Now, a number of those LLCs are taxed as S Corps, so some of those probably, S Corps probably closer to that 40 to 50 or so, be very, very close to that. But obviously you can see then the size of each one of those buckets within sort of the deconstructed business interest area. Cryptocurrency, we've done a lot of talks on cryptocurrency, and each time I try to emphasize great gifts, not so good the last couple of weeks, 3 weeks or so, as you know, but even though they're this super flashy thing and everybody wants to talk about them, $28 million is a lot. It's not a lot relative to $1.13 billion. So every charity that keeps calling them, like, please focus on business interest gifts and real estate. That's where all of the real wealth and action is. But still, we did 37 donations last year, so not an insignificant amount. Cash, we did almost zero with cash. You see no publicly traded securities. We don't do anything with publicly traded securities. And then other sort of super weird stuff that we have here that represent about $21 million. So again, the theme here is massive amounts of transactions last year from charitably inclined donors who are exiting as baby boomers, their business interest or their real estate, and they're trying to find an optimal way. All of these, by the way, 100% of these were outright gifts. We're also doing a fair amount in the CRT side and, again, the CGA side as well, separate from this. So I am more than happy now to turn it over to Russ, who I've known a long, long time. Many of you know Russ from GiftPL and probably every other listserv on the planet. Does a fantastic job. Been with us, I don't even know, Russ, 3 years at least now, 4 years perhaps, in various capacities. But so glad to turn it over, and I'm eager to hear your comments.
Okay, well, thank you, Brian. Are we still in a place where you're going to have to do the slide advance? Sorry about that.
We are, and glad to do it.
All right. So, yeah, we promised 5, and you're going to see a lot more than 5, but we sort of put it into 5 categories. We have the emergency charitable incentives that are expiring, obviously. We have some activity going on in Congress right now. I think when we get to the details there, you'll see that there's not really anything that we can anticipate actually happening there. There are several places in which IRS has made a determination that they are no longer going to issue private letter rulings, advanced determinations, and we'll talk a little bit about well, there's plenty that they've done, but 3 that affect our charitable planning practice. And then a handful of court decisions and some pending, actually, I should say litigation, I hope. But that's what happens when we have multiple people not really proofreading. But let's plunge in. Let's just start with the emergency provisions expiring. So, all right. We did have, for 2 years, something called an unlimited itemized deduction, unlimited in the sense that you can deduct up to your adjusted gross income. And that's gone, but it's not April 15th yet, or October 15th if you're on extension, and we still have an election to make. How much of your cash contributions from 2021 are you going to actually elect to deduct above and beyond what would have been the 60% limitation? Keeping in mind that the very last dollar that you elect, you've brought your adjusted gross down to almost 0. That last dollar is going to be deducted at only 10%. So there's probably some logic to electing less than all of your cash contributions for the unlimited deduction. And anything you don't elect is just going to be a cash contribution that carries forward to the following year, where it will be subject to the 60% limitation, which is also temporary. That's expiring at the end of 2025. The problem with the 60% limitation is this. If you are also deducting non-cash contributions, which is certainly everything we talk about around charitable solutions, those are going to be subject to the 30% limitation. And the problem with the 60% limitation is that the 30% limitation is still calculated with reference to 50%. Okay, I'm approaching this maybe by the back door. Any cash contributions for which you have not elected the unlimited itemized deduction are going to fall within the 60% rule, and you're forced to deduct those up to 60%. And everything above 50% is going to drive down the availability of your 30% limitation. So you only have 5 years to carry forward. And in some cases, you could literally lose a carry forward year because your cash contributions are going to drive out the deductibility of your lower limited deductions. So then you have two considerations going on when you're trying to elect how much of your cash contributions you're going to claim the unlimited deduction for. One is the fact that you're going into lower and lower marginal rates. But the other concern is that to the extent you don't elect it, those cash contributions are still going to be deductible up to 60%, and they're going to force carry forward on some of your lower limited stuff. So you need to elect some of it. It's a drafting error, unfortunately, in the 60% limitation, but the Congress has chosen not to do anything about it. And as I say, it will expire in 2020, at the end of 2025. I'm holding my finger over the advance button as though I'm going to advance. Brian, let's move to the next slide. Okay. The other thing that is expiring is this temporary above the line deduction for non-itemizers. I see a signal here that people are raising their hands. If there's a concern going on there, maybe we should put that in the chat window. So the real question is, was this temporary measure to allow this nearly meaningless amount for non-itemizers to deduct above the line, was that somehow a foot in the door for making something permanent that would allow non-itemizers to deduct cash contributions to charity above the line without having to itemize? Because as you know, especially now with the standard deduction having been doubled along with everything else in the 2017 tax bill, there are even fewer. It used to be maybe a third of people itemized. Now it's more like 10, 12%. So there's a lot of non-itemizers out there who don't have a tax incentive for cash gifts to charity. That's what this is kind of about. There are two bills pending. There's been no movement on either of these bills in more than a year. I'm not optimistic that either of these bills will move. But one of them would allow non-itemizers to claim up to 1/3 of the standard deduction amount above and beyond the standard deduction itself. And even if that bill is enacted, it's still only for last year and this year. It's another temporary emergency measure. I think maybe Congress is beginning to feel that the pandemic is kind of over and we don't need these incentives anymore. I don't know what the thinking is. Then there's another bill, 1081, which would move the entire charitable deduction above the line altogether for everybody. And itemizers would just be left with, medical and tax, state taxes and so forth. But of course, doing it that way, if it's still subject to the percentage limitations under Section 170, that gets you involved in circular calculations, because what is your adjusted gross if you're moving percentage limited charitable deductions above the line? So, but I don't expect to see movement on either of those bills, and there's nothing else pending. Next slide. So what is pending, there's a couple of things. One, Senate Bill 243, this has been around in one form or another for probably close to 20 years. And what it looks like has been sort of stabilized. We sort of know what the legacy IRA will look like when it finally gets enacted. When it'll finally get enacted, I don't know, but it's been introduced enough times and with enough credible names behind it, sponsors, that I think the day will eventually come. And what it will look like is you take the existing structure for QCDs, the $100,000 per year outright to charity above age 70 and a half, and layer on top of that the ability to also make direct contributions from a traditional IRA into a life income plan, like a charitable remainder trust or a gift annuity. That would be the deduction problem with numbers. Okay, in a different version of this program, I did that, and if we have time at the end, we'll talk a little bit about numbers. So the shape of this bill has always been, let's allow people to give up to $400,000 per year, but up to 300 of that can be into a life income plan. If you do that, when they started talking about this, they were allowing it all the way down to age 59 and a half, anytime that you would be eligible to take distributions without penalty. Now they're talking about age 65. The payout would be entirely ordinary income. It would be just the participant and or her spouse, and it would not be assignable. I had a conversation the other day with somebody from Sterling. I said, I'm suddenly understanding what non-assignable is about. You set up a charitable remainder trust, and then you make an assignment of your life income interest to some other structure. That's something they don't want to allow in this bill. If you're going to make an assignment, it'll just be an acceleration to the remainder charity. The Joint Committee estimates that this will actually have a significant revenue cost. Not huge, but significant. And at first I thought, well, how can that be? This is money that would have been taxable anyway. You're simply rolling it over into a life income vehicle, which is going to be taxed at 100% ordinary income anyway. And I literally talked with Tom Berthold over at the Joint Committee, and he said, well, the problem is this. Think of somebody with a huge IRA, and they take out $300,000 or $400,000 and put it into a charitable remainder trust. Okay, that is $400,000 that would have been taxed this year. Okay, but they're spreading that now over their life expectancy. So that's going to have a revenue cost. And I have to admit, I had not thought of it that way. And actually his estimate, which you can retrieve through the Joint Committee website, also makes comparisons. Well, what if we imposed a lower limit, something less than $400,000? What if we restricted it to people at an even higher age than age 65? What if we put aside the idea of being able to fund a charitable remainder trust and instead just did charitable gift annuities? Each of which has a lower revenue cost than the existing proposal. So let's look at the next slide. And I think there are like 4 slides here that are in a group. You may have heard of this. There's a project afoot. A couple of sort of rock star law professors, Ray Madoff and, I led myself into a corner where Roger Cullenbaugh, with a fair amount of money from the John Arnold Foundation, have been putting together this legislation. It is pending. It has sponsors on the Finance Committee, which would radically change the landscape with respect to donor-advised funds. And it's easy to see that the target, of course, is the commercially sponsored donor-advised funds. And what they want to accomplish with respect to at least that class of donor-advised funds is that they don't just sit on cash for more than 15 years. That to qualify, and we'll talk about what it means to not qualify under this bill in a moment. To qualify, the DAF would have to be set up in such a way that it will be exhausted within 15 years. There's an exception carved out for community foundations, but only some community foundations. So you can't have a service area larger than 4 states, and you have to have assets, significant assets that are not committed to donor-advised funds. And even with respect to a particular donor-advised fund, it can't hold more than $1 million, and it has to have a minimum 5% payout. So this would be a substantial change over the environment we live in now. Next slide. So if you have a non-qualified DAF, you simply would not get a deduction at the front end for a non-cash contribution unless that contribution was eventually sold for cash. And even then, you don't get a deduction until there is a qualifying distribution. And a qualifying distribution is not a distribution to a supporting organization or another donor-advised fund, things like that. You get no deduction at all for a contribution of non-publicly traded assets until they're actually sold. And then your deduction will be limited to the proceeds. And again, your deduction occurs only when there's actually a qualifying distribution to be made. If you don't get everything out the door within 15 years, there will be a 50% penalty on what's left. Okay, next slide. And then there's also a part of this bill that deals with private family foundations. Okay, sitting here right now, if you have a private foundation and you have family members employed on the board or in the administrative functions, their salaries can be counted toward your qualifying distributions. This bill would negate that. Any person who would be a disqualified person with respect to the foundation, you can pay them a salary, but it's not going to count toward your qualifying distributions. And the same if you make a distribution from a private foundation to a donor advised fund, doesn't count towards your total. Distributions from a donor advised fund sponsor into a private foundation are not going to be counted toward public support. So this kind of messes with your private public status. Take a look at the next slide. So, because we don't want to spend too much time on ACE, it will eventually, something like this is probably going to be enacted eventually, but for right now, it's just something scary on the shelf. Are you able to advance? Yeah, go ahead.
I can, and I don't want to spend much time on this. However, being in the donor advised fund space now for almost 30 years, I guess, the only thing I would say for all charities, and this is the opining, so this is not Russ's comment or anything else, but from a tax policy standpoint, I think that there can be some cogent arguments made for when the money is going out, we're taking sort of tax deductions now. The only thing, as devil's advocate on the other side, that I think we all need to be very, very careful about is when we talk about essentially sort of creating the boogeyman that is the donor advised fund. We operate them. We work with most all, if not all, the national donor advised funds, tons of community foundations. Many charities are saying, and some of those professors, let's be blunt, and other advocates, completely fine, are taking the position that this is sort of a warehousing or a stockpiling of money that's otherwise not being used. The thing that I would just point out from a sort of general factual point of view is National Philanthropic Trust and others, put out surveys. There are some disputes as to the methodology for the surveys. I get it. I've seen all of that. But generally speaking, the donor advised fund payouts are between about, let's say, 18% typically for community foundations, usually closer to that 22-25% for national donor advised funds. The difference there is many community foundations have endowed donor advised funds, which pull down their payout to the spending policy. Some national donor advised funds have those as well. My only point is that a lot of this is around getting the money out quickly and only providing tax incentives for those that do, or forcing this 15-year sunset or some level of sunset. What does this mean to all the non-operating private foundations that exist in this country that have probably 5 to 10 times the overall assets, if not more, of all donor advised funds? They're exactly the same thing without necessarily this sunset, number one. Number two, there's something around behavioral economics and behavioral finance, where, as a super quick example, no one on this call, we got 300, nobody on this call thinks we should have more profanity in songs. No one, no, it's like I'm super pro profanity. And so we remember Tipper Gore went through that process in the 80s to get the parental explicit lyrics label. And what happened? It was to protect the kids. And the moment that label hit it, and it was locked behind, at that time, record stores, that's all the teenagers wanted to have, is they wouldn't buy anything unless it had the explicit label. This is 100% true. Those sales went up 30 to 40%, so much so, can't make this up, that producers went back in to artists to say, I know you never curse in your music. You got to jam some words in there because we have to have the explicit label. That is true. Think about our movies. The second you tell members of our species you must do something, they will do everything known to man not to do that thing, including admin expenses for private foundations subject to their otherwise 5% payout requirement. They don't, in many cases, give out 5%. They give out 4.72131% because they're able to deduct all these other admin expenses. And you tell them they have to do 5, they'll do everything possible not to do the 5. You tell donor advised funds it doesn't matter, and they're giving out 17 to 25%. Drives me a little bit nuts. That's my own comment, obviously. But the point here is, let's also take one other step to say, What does this mean for endowment funds? You're taking the deduction today for the scholarship that's going out in perpetuity. Why would you do that? This is in my view, a slippery slope around tax policy. We'll see where it goes, but as Russ says, not sure this is going to go anywhere, but this has been bubbling for 20 years. And so what the eventual manifestation of this looks like, we don't know. But again, just some caveats there. I'll shut up and I will advance.
No, that's actually some of what you're saying actually is something we can touch on the next slide. But I also kind of want to summarize with respect to your comments that they have worked very hard on this bill. It's a carefully drafted bill, but I think we can kind of look at it as a working draft. It's not going to get enacted this year, but the message that the people on this call need to hear is that something like this is coming. Okay, so we need to pay attention to that. But in relation to this business about 5%, 4%, how much are you going to force people to distribute? Another thing that this bill would do with respect to private foundations is relieve you from this 1.93% excise tax on net investment income if you're distributing at least 7%. Okay, again, a lot of foundations are distributing a lot more than that. In fact, with some of the foundations, small family foundations that I'm working with, they have this excess running year after year. And I tell them every 5 years, I say, you're going to waste this excess unless you cut back this year. Well, they don't want to cut back. Whatever. There were some questions that came up along the way. No, I don't think there's anything in here that would make this retroactive. And I don't think that there's anything in this bill that would deal separately with the fact that the original donor advisor might have died in the meantime. I think it's still a 15-year payout regardless. So let's take a look at the next slide. And that's enough for ACE for now. Okay, IRS has been active, or actually they've been active in telling us what they're no longer going to be active in. We'll want to talk about 3 of these. One is what happens if you set up a split interest trust that would qualify for the gift tax and income tax charitable deductions, but for one reason or another, you don't claim those deductions. And the result is that the split interest trust is not holding assets with respect to which a deduction was claimed. Several letter rulings over the years saying in that circumstance, you don't literally fall within 4947A2, and therefore the private foundation rules do not apply to that trust. Well, you can see that's probably a design feature for some folks. I want to put closely held stock into my split interest trust above and beyond the excess business holdings limits. I want to be able to engage in transactions that would otherwise constitute self-dealing. And IRS was issuing favorable rulings on this circumstance. And they've decided to no longer do that. I wanted to point out on this slide that there's a not terribly aggressive and fairly commonplace use for this kind of planning, and that would be in a non-grantor charitable lead trust. They already have a special rule that allows you, if your leverage is modest, less than 60% leverage, that you can hold stock in a closely held corporation in a charitable lead trust. But above and beyond that, if it's a non-grantor trust, part of what you're trying to accomplish is to leverage the gift tax value of the remainder to your kids and grandchildren. You don't need literally the charitable deduction to accomplish that. The present value of that remainder gift is already leveraged. So we're talking about a gift tax deduction. It's a non-grantor trust. You're already not claiming an income tax deduction. As the trust goes along and operates and makes these annual annuity distributions to charity, it is no longer holding those funds. So a non-qualified lead trust would literally never be holding assets for which a deduction was claimed. IRS, and you can, if you're concerned about, well, it's a charitable deduction, whether I reported it or not, there's a revenue ruling that says if you've reserved the power to sprinkle the annuity amount among charities that you select on an ongoing basis, you haven't even completed the gift to charity. So, that's a strategy that is out there, and it's something that IRS has said they will no longer give you an advanced determination on. Next slide. Another problem that people often come up with, the classic scenario would be during life, I have a closely held business, I sell the closely held business to what they call an intentionally defective grantor trust, and I take back a promissory note, okay? The idea there is to freeze the value of the closely held business. And yes, there will be some estate tax inclusion, but what's going to be included is the present value of the promissory note, okay? And then often you will leave that promissory note to your private foundation. Well, the problem then is that you have a self-dealing relationship between the obligor on the note and the foundation. So what people have begun to do is they would say, well, I'm going to place the promissory note into a limited liability company, and I will have a 1% voting interest and a 99% non-voting interest, and I will leave only the 99% non-voting interest to my family foundation. IRS issued favorable rulings on this many times. And what I've just described, you can take a look at the letter ruling that is cited there. As of last year, IRS has said we're no longer going to give advanced determinations on that either. It's not a dodge, it's not a scheme, it's just something where there is a potential for self-dealing issues, and IRS has said that they're no longer going to give you advanced rulings there. Next slide. This just came out a couple of weeks ago. IRS has now said that they will no longer give, and actually I've looked and I don't think they ever did give an advanced determination on whether a charitable remainder trust for the benefit of a spouse is eligible for a gift tax or a gift tax or an estate tax marital deduction if you give the trustee discretion to distribute part of the annuity or unit trust payout on an ongoing basis to the remainder charity. This is a mechanism that people do use to sort of regulate the flow of taxable income into the hands of the spouse. And if she's got a high income year, you want to maybe divert some portion of the unit trust payout directly to the charity. You don't get an additional deduction for doing that, but you limit her exposure to additional income tax. You could kind of accomplish the same result by having her go ahead and take the entire unit trust amount or the annuity payment and turn most or all of it over to the remainder charity and claim a charitable deduction on her own return. But that won't always be a wash, and it will often, in the high income cases, it'll take the spouse over the thresholds for the 3.8% Medicare surtax, and various other threshold triggers. So it's a mechanism that people use, and I would imagine that they're going to continue to use it without the benefit of IRS giving them a favorable ruling. And as I say, I don't think anybody has ever applied for a favorable ruling on this question. The issue, I talked this over with Larry Katzenstein briefly, and the issue in his view, and I think he's right, is that if the spouse is not entitled to 100% necessarily of the unit trust amount or the annuity amount, how do you place an actuarial value on her income interest in the trust? Because it's uncertain. And therefore, how can you claim a marital deduction for the full amount? It has to do with the value. It has to do with the valuation question. I think Larry's right about this, because there are so many other features of the marital deduction here that don't really, quote unquote, protect the spouse. You could make it a net income unit trust. You could limit her to a term of years. You could put in a qualified contingency that says your interest in this trust is going to terminate if there's a divorce or remarriage, or you fail to graduate medical school, or whatever. So it's not as though we're trying to protect the spouse here. It has simply to do with calculating present values, actuarial interests. So that's the news from IRS on no longer giving advance rulings. Something they did do, however, is they issued somebody in the chief counsel's office gave advice to a field office. And so you will expect to see some version of this case show up in litigation sometime in the next 2 or 3 years. Holder of closely held stock in a really highly valued corporation did a couple of things. One, put a fair amount of that stock into a grantor retained annuity trust, just a 2-year grant, in order to leverage a gift out to the kids, right? But unfortunately, in setting up that grant, he used an appraisal that had been done for, for his the company's qualified plans. Used an appraisal that was 6 months old, and in the interim, they had put the company on the block, and there were bids, and some of those bids turned into, one of those bids turned into an actual purchase at least 2 times the price that was being reflected on the appraisal. And at the time he set up the grant, those discussions were already underway. And so the chief counsel's office was saying, well, you can't ignore that. A hypothetical willing buyer would have known that there was a pending merger and would have taken that into account in setting the price at which she was willing to purchase this corporation. So that means that the value that was placed on the annuity in the grant was way undervalued. And the position that the chief counsel's office took was, therefore, the grant doesn't qualify at all, okay? Doesn't meet the requirements of Section 2702. So the remainder gift is now going to have a much higher value attached to it, at least in this examination, which, as I say, is likely to end up in litigation. Along the way, the same settlor, same transferor, also set up a charitable remainder trust, and for that purpose got a newer appraisal, a qualified appraisal, which, as Brian will tell you, is a lot different from a 409A appraisal. There are many, many more bells and whistles on an appraisal for a charitable deduction, and it was more recent, and it took into account the pending merger. Okay, so that actually passed, but we need to be aware, that you need a qualified appraisal in order to claim a charitable deduction. And if you're in a situation where events are unfolding and the price is going to be going up, you have to pay attention, and you have to be willing to eat some of that in your gift planning. Something that I noticed in this chief counsel memo that I think also matters for a discussion that we will have a few slides down the road here is that they spent quite a lot of time talking about an appeals court case out of the Ninth Circuit called Ferguson, which literally was not about appraisal. The issue in Ferguson was this a prearranged deal so that we should treat the transferor as having realized the gain before he made the contribution of the subject stock to the private foundation? And that is one of the rare cases in which IRS actually prevailed in the tax court and in the appeals court on an issue other than the way the issue was defined in Palmer. So we'll talk about that when we get to the Dickinson case in a few moments. Brian, have I given the kind of coverage to that CCA that you were hoping for?
Yeah, very much so.
Okay, so let's take a look at some recent tax court decisions that kind of affect, what we do in the trenches on charitable gift planning. I'm reaching back all the way to January 2020. This is like before the pandemic, kind of. It was already raging in China, but it was just coming here. Case is called Loeb, and it's a fairly unusual case in terms of, what is the asset that was being contributed. These people had a house they wanted to tear down and replace with a larger and better house. So they engaged the services of a not-for-profit that was in the business of salvaging materials and reselling them to people and training people to do the demolition work and the construction and deconstruction work. So it was a really, sensible gift. The problem is that the appraiser that they hired in order to substantiate their claimed deduction appraised the salvaged items as though he was doing something at replacement cost, taking into account depreciation, rather than the idea that they were, salvaged items as such. But more significantly for our purposes, when they filed their tax returns, the Loebs, they filed an 8283, as you need to do for a non-cash gift in excess of $5,000, but they left out the information that the tax court has repeatedly said you absolutely must put in these 2 data points: your adjusted basis in the contributed property and the date you acquired the property. Now, that could have been a pretty scrambled set of information in this particular case. You know, we have the kitchen counter over here, we have the shower head over there, and we have, you know, all the lathe and whatnot. So it could have been a pretty complicated statement, but they put in nothing at all. We're seeing this kind of thing in what I would call perfectly innocent cases. The Lobes weren't trying to pull anything. They just wanted to get a charitable deduction that they were fully entitled to for something nice they did for a local charity. The reason we're seeing this, and we're seeing ordinary people being punished, is because bad actors have been out there, and the tax court has been forced to make these kinds of distinctions in cases where IRS would otherwise have to go into extensive production of expert testimony as to valuation and so forth. So as a quick end run around that problem, IRS has been raising these technical issues, and the tax court has played along. If you want to see the origin of this particular problem, take a look at RERI Holdings back in 2017. Bel Air Woods is also one of these syndicated conservation easement cases. And it's in those cases where the tax court has said, yeah, you know, you need to put your adjusted basis and the date acquired on here, otherwise you have completely failed. So be warned. That's a red flag on Loeb. I think the next one is probably Warren, yeah. It's an unfortunate case where the taxpayer got whipsawed. This is an estate tax case. Decedent died holding, you know, this, that, and the other private enterprise in various LLCs. One of these LLCs, the decedent wanted to leave partly to his church and partly to his private foundation. The LLC was valued at 100% for inclusion in the estate for estate tax purposes, but by splitting the LLC into two different parts to make a partial interest gift over to the church and a partial interest over to the foundation, the decedent created minority interests and you know, less than 100% controlling interest in this LLC. So the charitable deduction, although the very same asset went out to these two charities, the charitable deduction was limited because the church was getting a tiny minority interest and the private foundation was giving an interest it couldn't fully control. And there's a citation to another Ninth Circuit case here where, you know, that this is not even news. That's why it's a memorandum decision. So that's Warren. Just kind of be aware that your charitable deduction is not always going to match 100% your estate tax inclusion figure. All right, I warned you that we're going to talk about Dickinson. How much time do we have? All right. This is a case that IRS lost. I want to be clear about that. But it's a very typical scenario. The taxpayer gave shares in a closely held corporation to a donor advised fund. And predictably, the donor advised fund promptly presented those shares for redemption by the closely held corporation. IRS wanted to treat this as a prearrangement that would run afoul of the Palmer rule and tax the taxpayer as though he had sold the stock and contributed the proceeds. Okay, this is an issue on which IRS knew they would lose because this is what I call the second prong of Revenue Ruling 78-197, which on its face is an acquiescence in the Palmer decision, but it puts a new rule on top of the Palmer decision. The Palmer decision was basically, if the redemption was already enforceable at the time that you gave the stock to the private foundation, then you will be taxed as though you had sold the stock first and contributed the proceeds. The situation in Palmer was to the contrary, and the tax court has stuck by its guns on this over the years. If there's not an enforceable agreement in place, even if everybody knows it's going to happen, that's okay. You're not going to be taxed on the contribution as though it were a realization event. In the revenue ruling in 1978, IRS took the position, well, but if it's a closely held corporation and at the time of the transfer, it is already the case that the corporation can force a redemption, then we want to treat that as though it's a sale and a contribution of proceeds. Tax court has never bought into that. And again, IRS lost this case and they did not take an appeal, but in their briefs, it is clear that they do want to argue this issue. And what happened to them was that it was placed on a summary judgment calendar before they had really launched their discovery. So my expectation is that you will see a better developed case along these lines. They will lose, but it'll be a case that's developed sufficiently that they can take it to an appeals court and try to get some reversal circuit by circuit by circuit to get the tax court to back off of their refusal to recognize the second prong of the revenue ruling. So, and that's why in that CCA that we looked at a few pages back, that's why I think it's significant that they are still referring to the Ferguson decision, because that's like a lonely win for them on this issue. So let's page ahead, I think. Yeah, okay, so these are the last two cases I think that we're going to talk about today. And I'll try to leave Brian some time at the end. There are two cases. This one is Fairbairn and the next one is called Pinkert. And they are both situations in which taxpayers, I keep calling people taxpayers, husband and wife, contributed a large amount of stock. It was actually publicly traded stock to a donor advised fund just literally the day or the day after there was a huge price spike in this stock because of some FCC regulation involving the technology. These folks actually already also knew that a couple of months out, a significant engineer in this company was going to resign, and so there might be a fall off in the price. So they wanted to hit this sweet spot, and it happened to be December 28th. But it was, like $60 million worth of this stock. Fidelity, as they, inevitably would, immediately began to sell it. The problem was that they immediately began to sell it on the same day as the gift, and the price fell dramatically during that day. So we ended up in court litigating whether it was somehow Fidelity's fault that the price fell, because the Fairbairns felt, well, they flooded the market. And everybody could see, that there was too much stock chasing too few dollars, and that's what happened. Ultimately, you can advance the slide, Brian. Ultimately, they really weren't able to prove that. They actually went to trial over 7 days. This was during the pandemic. It all took place on Zoom. You were able to watch it if you wanted to, and I did watch some of it. 7 days of expert testimony, what was our method for dumping this stock, and what are the many possible explanations for why the stock tanked that day. But what matters for us, and the reason I'm looking at this decision and why we're going to look at the Pinkert case in a moment, is the whole theory of the case was I contributed stock to a DAF, but somehow I still have rights to tell you, Fidelity, how to manage that stock, okay? And Fidelity's argument was, it's not yours anymore. It says so right here on the paper. You've given us this stock, it is ours, okay? Something bad happens to it, that maybe is a problem that the state attorney general can address. Maybe we did mismanage it, but it's not you who can enforce that. And the reason, you and I need to pay attention to this is if anybody like Fairbairn, they did not take an appeal here, incidentally. They lost the case, they did not take an appeal. But if anybody in their situation ever prevails on this argument, we have a problem in that the question now is whether we've made a completed gift. If you haven't made a completed gift, you don't get a deduction at all. So let's take a brief look at the Pinkert case, which I think is on the next slide. These folks kind of saw what was going on in Fairbairn, and they said, we want to go to the appeals court. We want the Ninth Circuit to actually rule on this question. Does the donor have any rights with respect to the fund sponsor for their management of the investments? So it's nominally a class action, but both sides in this litigation cooperated in getting things done on motions to dismiss. Does this even state a cause of action? And they got the whole thing taken care of on heavily briefed motion to dismiss so that it could go straight to the appeals court without the 7 days of expert testimony. So that is pending appeal right now. The briefs, I think we haven't got the reply brief in yet, but most of the briefs are already in. And the Ninth Circuit is going to be confronted with the question, does a donor to a donor advised fund have continuing rights to say, to enforce? In this case, the question is, Schwab is primarily investing in Schwab sponsored vehicles, and maybe there was something better available on the market. Schwab is taking fees for its management of these funds, and maybe they could have gotten a better fee structure elsewhere, that kind of thing. But this was set up in order to go directly to the appeals court. Now, I don't know that I have a second page on this slide, on this case. If not, I think yeah. So I just wanted to conclude by saying a lot of the stuff that I just skimmed in, 30-second bites, I go into in a lot more detail in a newsletter that I cheerfully invite you all to take a look at. There's a complicated URL there at the top of the page called the Jack Straw Fortnightly * or occasional. And it's not all tax law. Some of it is non-tax case law out of the various states dealing with, trustee responsibility and so forth. So, Brian, you got 5 minutes. I think I left you 5 minutes at least.
I appreciate that. Well, thank you very much, Russ, for going through this. I think the main thing is you can see a lot of the activity continues to be around sort of donor-advised fund clarity, to the extent that there is any, between sort of rights, responsibilities, processing, as well as certainly on the non-cash side, the valuation piece keeps coming up, and then certainly too around the, what is a prearranged sale, how far is too far. So sort of all of these are things that we are working within. And while certainly these cases are on specific charities, I think many charities have exactly the same issues. Certainly every community foundation that I've worked with has very similar issues. So these are where it's important. And Russ, I appreciate you sort of taking us through what the more recent landscape is to better discern, to the extent that we can, the IRS's posture around this, or certainly the court posture around these particular cases, to the extent that we can sort of read the tea leaves a little bit too. And I really would, anybody who there are tax geeks and then there are super tax geeks, so Russ is the latter. And so for those of you who are similar, definitely you might want to subscribe to this. Again, it's free, and you can sort of just go right on that website to be able to sign up. The last piece here is really just our past free webinars. Similarly, you can see the Charitable Solutions site under resources. We've got, I don't even know what that is now, 15 of them, all free like this will be. There was one question that popped up, Russ. I don't know if you had heard the latest, but around any kind of clarity about donor-advised funds being able to fulfill legally binding pledges, because I know that had been part of the
IRS, I don't have the notice number in front of me, but IRS issued a notice, I think it was way back in 2016 or thereabouts. Basically their policy has been, and I don't see a reason for them to offer any more clarity on this, because they're probably satisfied with this, but their policy is basically don't ask, don't tell. And the reason is that only the recipient charity really knows whether they may not even know, they probably have an opinion as to whether the pledge was legally enforceable. So what IRS suggests you do is just don't mention the pledge in acknowledging the gift. Yes, we got your gift. And actually, if it's from a donor advised fund, the acknowledgement is going to the fund sponsor anyway, because you've already claimed your deduction for your gift into the donor advised fund. You're not getting a further deduction. The issue, of course, is, can I use my DAF to buy the $100 ticket for the dinner when, $20 of that is for the dinner and the other 80 is a contribution? Answer, no. And in fact, what the notice also said was you can't even use your DAF to pay the 80, okay? Because that's sort of your ticket to getting the $20 dinner. Can't do it at all. But also on enforceable pledges, IRS basically said, we're not going to get into the question whether some particular pledge was enforceable or not. Just don't mention it in acknowledging the gift. Don't mention the pledge. So that's kind of where we are with that. And I do not expect to see further guidance on that.
Well, and it does. We're actually working on a case now too, where the charity itself, based on a new program that they wish to create, is looking for the legally binding pledge from the donor advised fund sponsor. And so you have it sort of in reverse in some way, to where it's actually, I don't want to say conditional to the gift to create all kind of issues there, but as a component of the gift to get the charity sort of comfortable moving forward with a particular project. So there's still a number of degrees of nebulousness in sort of that space, as well as there always is. But so appreciate everybody joining here today. I think we are, Russ, a fantastic job. We are dead on 1 o'clock Eastern time. I do know that there are a number of chat and Q&A pieces that have come through, and so to the extent we were not able to answer all those, we will. So we'll compile the ones from this session, the one from next Tuesday's session, and then we'll get those out as a summary with the link to the recording. So again, hope all this is helpful. Anything that we can ever do, to certainly let us know. And I would again encourage you to go to Jack Straw Fortnightly and sign up, if nothing to hurt your brain from time to time as you sort of go through some of those case dissections that Russ goes through. So thank you again, Russ. Thanks so much. Appreciate it.
Thank you, Brian.
Great. Thanks, guys.